How does a lawyer represent a client whom they know is guilty?
That question presupposes an answer to another question. Can a lawyer even represent someone whom they know is guilty? The answer to that question is yes, but yes with a but. Stick around, it's going to be a good conversation. Viva Frei, Viva Frei, Montreal litigator turned YouTuber. I do these things called vlogs, VLAWG, where we break down and analyze something that's going on in the legal world in terms that can be understood by lawyers and non-lawyers alike. The other day I was on a podcast called The Switch, and we were talking about law, and the podcast host asked me something about how a lawyer defends a client whom they know is guilty. And I'm not trying to impute any ill intent to this question. A lot of people ask this question, but they ask it with sort of a judgmental frame of mind, like, how can a lawyer do such a thing, defend a client that they know is guilty? And I gave him a thoughtful answer, and after the answer, he said, "Holy cows, you just changed my mind." And I said, this is going to make an awesome topic for a vlog. Okay, down you go. So in answering this question, it's necessary to analyze some of the basic ethical framework within which lawyers have to practice the practice of law. And although this is not going to be a detailed and thorough comparative law analysis, I briefly looked over the rules under the American Bar Association, and it looks like the rules are by and large the same, but let's just start with the Quebec Code of Ethics for Lawyers, shall we? Code of Professional Conduct of Lawyers. Act respecting the Barreau du Québec Professional Code. Preamble. Whereas a lawyer is a servant of justice, whereas the practice of the profession of lawyer is based on the following values and principles which a lawyer must take into consideration in all circumstances. 1. Compliance with legal provisions and preservation of the rule of law. 2. Access to justice. 3. Respect for individuals and protection of their fundamental rights, including the right to be free from discrimination and harassment. 4. Integrity, independence, and competence. 5. Loyalty to clients as well as protection of their legitimate interests and the confidentiality of information concerning them. 6. Collaboration in the sound administration of justice and the support for the authority of the courts. 7. Respect for the honor and dignity of the profession. 8. Respect for the members of the profession as well as other persons with whom the lawyer collaborates when engaging in his professional activities. And 9. Consideration for the social context within which the law evolves. And this highlights a very important dual role that lawyers serve that a lot of people tend to forget, especially clients. Clients say, "You're my lawyer, you do what I say, you represent my interests at all costs." Lawyers are also officers of the court, and they have an obligation towards the sound administration of justice and the authority of the courts, which means that there are certain things that a lawyer is not allowed doing, even if it is in the pursuit of the interests of their client. And that is going to be the zone that we're going to get into when discussing what a lawyer is entitled to do when defending a client whom they know is guilty. But first, let's just read a few more provisions of the Code of Ethics to first establish that a lawyer can, in fact, represent someone even if they know that that person is entirely guilty. Article 8. A lawyer who offers his professional services cannot, by any means whatsoever, make or allow to be made a representation that is false or misleading, that amounts to coercion, duress, or harassment, or that seeks to take advantage of a person who is vulnerable due, in particular, to his age or his physical or psychological condition. The second part of that provision is more or less relevant to this discussion. It's the first part that is particularly relevant. A lawyer who offers his professional services cannot, by any means whatsoever, make or allow to be made a representation that is false or misleading. Bear that in mind for the rest of this vlog. Article 19. A lawyer must not, directly or indirectly, publish, broadcast, communicate, or send writings or comments which are false or which he should know are false, or assist anyone in doing so. Article 32. A lawyer may agree to act for a client no matter what his opinion may be on the client's guilt or liability. And finally, two more provisions before we get into the substance of this vlog. Article 117. A lawyer must not suppress evidence which he or the client is obliged to preserve, disclose, or produce, or participate in the fabrication of evidence he should know is false. And finally, Article 122. A lawyer must not knowingly permit a witness or a party to present himself in a false or misleading manner or to impersonate another person. We are obviously more interested in the lawyer not being allowed to permit a witness to present himself in a false or misleading manner. So what does this all tell us? A lawyer can in fact represent a client whom he knows to be guilty, but in so doing, he is not allowed to present false evidence or allow false evidence to be presented. And this goes back to an anecdote from my childhood. My best friend's father was one of the best criminal lawyers in all of Canada, and I had asked him this question: how do you defend someone knowing that they are guilty? And his response stuck with me for the rest of my life. He said it's not because someone is guilty that they don't necessarily have any form of a defense or mitigating factor surrounding their guilt. Someone can be guilty of the act but still have attenuating circumstances surrounding the act that ought to be raised in their defense. And you can defend someone who is guilty but not defend them on the basis of their innocence. Classic examples are crimes of passion. Somebody walks in on their spouse having an affair and absolutely loses it and commits a heinous crime. The question is not of their innocence, but rather what crime are they guilty of. But those types of situations where a lawyer is defending a client whom they know to be guilty of the act are not the types of situations that people are referring to when they say, how does a lawyer represent someone whom they know is guilty? The types of situations that a person has in mind when they ask a lawyer that type of question is the situation where the client says, yeah, I did it, I don't want to admit it, and I don't want you to defend me on the basis of mitigating circumstances, I just want you to defend me. How then does a lawyer go about defending someone whom they know is guilty, not on the basis of he committed the act but there are attenuating circumstances, but rather make them prove their case, I am innocent until proven guilty? And that is where we get into the code of ethics as to what a lawyer is allowed to do and what a lawyer is not allowed to do. Hypothetically, a client admits to his or her lawyer that they committed the crime. Okay, what does the lawyer do now? Given the provisions of the code of ethics that we just saw, the lawyer is not going to be able to defend the client on the basis of his or her innocence. The lawyer is not going to be able to get up there and say, my client is innocent, knowing that his client is not innocent. The code of ethics creates distinct obligations as to what a lawyer is allowed to do in defense of a client whom he knows is guilty. He cannot present false evidence. He cannot allow for false evidence to be adduced. He cannot ask his client a question knowing that his client is going to lie under oath in response to that question. He can't ask his client, are you innocent, knowing that his client is going to say, yes, I am innocent, knowing that that is in fact a lie and perjury. That would be a lawyer assisting in a witness providing false testimony. So how does a lawyer go about defending a client that he knows is guilty without breaching the provisions of his code of ethics? And it's here. Go away, wasp. Sorry, I don't like wasps. Barney came to the rescue. Get that. You don't want to get that wasp bite. It's going to sting your face. It's going to make you even uglier than you are. Get out of here. How does a lawyer do it while respecting his legal obligations under the code of ethics? And in an even more broader sense, is it ethical, not in the legal sense, but in the moral sense, for a lawyer to represent a client that they know is guilty? And I'm going to give you the answer that I gave on the Switch podcast, and you'll tell me what you think afterwards by commenting in the comment section below. So first and foremost, if a lawyer is representing a client that they know to be guilty, they are not allowed to produce or participate in the production of evidence that they know to be false. In criminal proceedings, the accused cannot be compelled to testify against themselves. It's up to the Crown to prove the case beyond a reasonable doubt. So the easiest thing in a criminal trial, if the lawyer knows his client is guilty, is not to call his client to testify. The prosecution cannot compel the defendant to testify, but the lawyer knows that if he calls his witness to testify, the witness is going to have to answer questions. Not only that, but the witness is likely going to have to answer questions from his own attorney, and the lawyer is going to know that the answers to those questions are going to be lies if the witness is in fact going to get up there and maintain his innocence, having admitted his guilt to his lawyer in confidence. So the lawyer cannot call his own client up and ask his own client questions knowing that his client is going to lie under oath, so the lawyer just doesn't call his client as a witness. And the lawyer says, prosecution, prove your case beyond a reasonable doubt. Some people are going to look at this as lawyer trickery, a sneaky defense attorney looking for any hiccup, any mistake, any technicality in the prosecution to get someone that they know is guilty off the charges. And this may be true, but bear in mind that a defense attorney is not only defending their particular client in that particular situation. The defense attorney is defending the entire administration, the entire prosecutorial process, innocent until proven guilty. And if a defense attorney does not test this process with vigor, even if they know their client is guilty, it's only a matter of time before the process loses its vigor and integrity in general. And as difficult and counterintuitive as it may be, you have to look at it this way. The defense of a client whom an attorney knows is guilty, to the extent that that defense is not predicated on false assertions of innocence, innocent until proven guilty beyond a reasonable doubt, is not about the guilt or innocence of any one particular accused. It is about the process as a whole. It is a cornerstone of a free and democratic society. And if the process is compromised in respect of a defendant who is guilty, it is only a matter of time before the process is going to be compromised in respect of a defendant who is innocent. Now, defending a client whom you know is guilty is kind of easier in the criminal sense, only to the extent that the prosecution cannot compel the defendant to testify. It's a little more complicated in civil proceedings because the defendant in civil proceedings can be compelled to testify by way of subpoena. So the lawyer has to prep their client for cross-examination by the opposing party and also gets to examine their client in front of the judge if they so choose. But even if they don't choose to call their client as a witness, the opposing party can subpoena the defendant and compel them to testify in civil proceedings. So how do you prep your own client for cross-examination by the opposing party and for your own examination, knowing that they are guilty without giving them the chance, encouraging, promoting, or allowing them to give false testimony under oath? It's a very tricky situation because a lawyer cannot participate in the production of false testimony. So a lawyer can't ask his or her client a question knowing that the client is going to lie. Moreover, if a lawyer asks his or her client a question and knows that the answer provided is false, what does the lawyer do then? There are diverging doctrines as to what a lawyer is supposed to do if they know that their client just provided false evidence or lied under oath. And you can imagine the complexities and the issues that are at stake with this. If a lawyer asks his client a question under oath and he knows that the client just lied, he can't reveal this to the judge because it would be breaching solicitor-client privilege. He can't just get up and withdraw from the file either because that would be the red flag that his client just lied and that the case is over. And the general consensus is that if a lawyer asks his client a question and he knows that the client lied in the answer, that the questioning has to stop there and the lawyer can't pursue that line of false testimony any further. These are sort of the exceptional circumstances of when things go wrong when a lawyer is representing a client whom he knows to be guilty. Generally, it's a question of sensitizing the client to the fact that the lawyer cannot participate in, assist, or in any way encourage the production of false evidence or false testimony. The lawyer doesn't have to ask his client certain questions, and the client can in fact lie, and if the lawyer doesn't know the client is lying, the lawyer is not at fault. And all of these extreme situations, they're really outlier situations. Typically speaking, when a lawyer is representing a client whom they know to be guilty, the issue becomes one of settling the case as quickly as possible and as favorably as possible for the client whom they know to be guilty. It will happen that a client comes to a lawyer and says, yeah, I owe that person money, but I'm not paying that person a damn cent because they were sleeping with my wife, so let them sue me. Okay, fine. Client is guilty. To the extent that the lawyer does not encourage or allow the witness to provide false testimony, the lawyer can use any legitimate defense that may exist in law even if their client does in fact owe the money. But typically the lawyer is just going to jockey for a negotiated settlement because nobody likes going to court when they know their client is guilty. And it's a risky proposition as well because a client may be guilty of certain accusations, but if they go to court and raise false defenses, lie under oath, they can be found guilty of other offenses as well. And so there you have it. A lawyer defending a client whom they know to be guilty is not so much a defense of that client as an individual, it is a question of maintaining the integrity of the process as a whole. It is not because the client is guilty that the lawyer is guilty of anything, and it is nonetheless possible for a lawyer to represent a client whom they know to be guilty with total integrity. If you like this video and you like my content, be sure to like, share, subscribe, hit the notification bell, and share my channel with someone you care about. And if you want some Vlog Dog merch or the Keep Calm and Vlog On, that's the new design, I'll post a link below, and now you know your vlog. Peace out. Boom.